Welcome to the firm's guide to relationship property law. This is part 2 of our 6-part legal education series. Ash, what comes to mind when you think relationship property law?
I think probably just the uncertainty, I guess, that people have around relationship property. What is the law? Who does the law apply to? What is a de facto relationship? What is a prenup? Does a claim arise in a de facto relationship after 2 years or 3 years?
Yeah, that last one's a funny point actually, because I swear there's someone going around the pubs of New Zealand telling people, hey, if you're in a de facto relationship for 2 years, you have to split everything 50-50, which, as we know, it isn't correct. It's 3 years.
Yeah, a lot of people do think 2 years.
Okay, well, let's start with the easy question. What is the law? Where does that come from?
So the legislation in New Zealand regarding relationship property is the Property Relationships Act 1976.
Yeah.
So it's been around almost 50 years. The Act applies to couples who are married, who are in a civil union, who are in a de facto relationship of 3 years or longer. There are some exceptions to this for de facto relationships of less than 3 years, but we won't go into that today.
Okay. So, what exactly is a de facto relationship?
So essentially it's a relationship between two people who are living together as a couple. So that can be quite hard to determine in some cases, and there is a lot of case law about this. But basically the Act provides a list of factors that can help the court and lawyers in the assessment of what qualifies as a de facto relationship. So things like whether the couple share a house together, or a common residence. You can be in a de facto relationship and be flatting. Financial dependency, a mutual commitment to a shared life together, how the couple's relationship looks to the outside world, to their friends and family.
Yeah, okay. Cool. I actually remember a case from university where a gentleman was in a marriage and a de facto relationship at the same time. So I don't know how he quite managed that, but he ended up splitting a lot of relationship property with more than one person. Anyway, so just to wrap that up, we've got the Property Relationships Act, which says marriages, civil unions, and de facto relationships of 3 years or longer generally are captured by the Act. We've established what a de facto relationship, what factors are taken into account to establish a de facto relationship. Now, Section 11 of the Act says any of those relationships that are captured by the Act, if those parties subsequently separate, there's a default rule of equal sharing of relationship property. So, by that I mean 50-50. And relationship property, as you know, is under the Act the family home, the family chattels, and all property acquired by the parties while they're in a relationship.
So things like income, I think people sometimes don't realise that income, KiwiSaver are things that come under that.
Yeah, exactly. And if one person's income's here in the relationship and the other party's is here, that's irrelevant. It's all in the pot, the relationship property pot together. And the family home and the family chattels are an interesting one because, again, it doesn't matter who brought the family home to the relationship and how much it's worth. The default rule is that goes 50-50. So if you take a de facto relationship of little over 3 years, and that's quite a severe outcome if someone brought a $2 million house to the relationship and the other party didn't, right? All right, so relationship property, default rule is 50-50. And how do you get around this? If you're really against this because there's a massive imbalance when you enter a relationship, what are the options there?
And that, I guess, is where your prenup comes in, as we know of them from American movies.
Did you learn that from Legally Blonde, did you?
Probably.
Yeah.
In New Zealand, they're called a relationship property agreement or a contracting out agreement. And essentially, you're contracting out of the Act. You're contracting out of the provisions of equal sharing and setting your own rules for how you want your property to be divided in the event that you separate.
Yep, and each party to the relationship needs independent legal advice on a relationship property agreement before they sign it. And that, as you say, that defines what is separate property that one party takes away and the other party takes away their respective separate property, and what relationship property is, and which will go 50-50. All right, so in a nutshell, we've got marriages, civil unions, and de facto relationships of 3 years or longer captured by the Act, and if any of those parties separate, the default position is 50-50 split of the family home, the family chattels whenever they were acquired, and other property acquired during the relationship.
And family chattels are just add there are things like, you know, your appliances, your furniture, your vehicles,
boats.
your boats, your caravan, your household pets are even considered a family chattel.
Yeah, so those are all 50-50 under the default rules of the legislation. Okay, but if you're not happy with that, or a party in the relationship isn't happy with those default rules, you can sign a relationship property agreement and set your own rules for who takes what if an unfortunate thing happened and the parties separated. Right? Great.
I think another important thing to just mention is when you talk about separate property, is things like, you know, an inheritance. You know, there are ways to protect that and keep that separate.
Yeah, exactly. The Act does have a section that specifically says inheritance, property or
taonga.
Yeah, property received from a third party is separate property in the first instance. However, if someone intermingles that into the relationship, it can lose its identity. So a classic is someone gets an inheritance, puts it on the mortgage and the debt on the family home with their partner, and 10 years later they separate. That's intermingled, and it's really hard to prove and get that back as your separate property. It's usually 50-50. So again, people need to be aware of relationship property agreements and define inheritance as separate property if that's the intention. All right, so I guess another important point to mention is this is a really generic overview of the Property Relationships Act. There are a number of sections in there about exceptions and post-separation contributions and adjustments. So it is important not to rely solely on the information in tonight's presentation, but to obtain your own legal advice on the topic of relationship property. But if anyone would like an explanation of any of the points we've covered tonight, feel free to get in touch with us. Thank you.